This is the current federal tax developments for the week of January the 13th, 2025. Current federal tax developments are presented by your state society of CPAs and by Kaplan Financial Education. This week, we got a number of things happening. The IRS was busy during the week. We're going to look first at the IRS grant of tax relief to California wildfire victims. That's not surprising that we got additional relief beyond the base provided in the code now, but it does give us the official deadlines now. So we'll talk about what we've got for the moment and how broad the coverage is for the moment. We're also going to talk about the National Taxpayer Advocate's report to Congress and legislative recommendations that were released by the Taxpayer Advocate this year with their annual report to Congress. We will also discuss here, Third U.S. District Court has issued an injunction related to the beneficial ownership reports of the Corporate Transparency Act. This one probably won't make a big difference unless Supreme Court comes down in a very narrow ruling that could impact this. But otherwise, I think we're probably just seeing this as just out there, may provide protection for the two plaintiffs in the case. In this case, we're going to talk about the tax court finding a building was not a certified historic structure as defined by Section 170H. So we'll talk a little bit about that background in a new reported tax court case. We also will get into a position where a taxpayer on an exam ended up asking the IRS potentially to refund the money, depending upon whether the treatment in question would be a method of accounting or not. The IRS issued the refund, which would only be due if it was not a method of accounting, but an error. And then the taxpayer tried to recover funds related to the years that were closed to adjustment. So we'll talk a little bit about what the issue was here, which is a very odd part of the code that we're not going to spend a lot of time on details because most of you are probably not working with taxpayers that have taken over failed financial institutions with federal government assistance. But then we'll talk about why method of accounting versus error is an issue and why that was such a big deal here. And definitely it cost them a bit of money, shall we say, the ruling the way it went. We have the Seventh Circuit upheld the imposition of a fraud penalty for overstatement of withholdings. The taxpayer had worked a unique view of how to do a tax scam where you overstate your withholdings and you overstate your wages. And that can get you a refund if done properly. So you didn't understate your income or understate your tax, right? So can't really get a penalty for understatement of tax. Turns out, yeah, you can. We also have the court found that this one goes above and beyond. Another fraudulent one. But this case, the taxpayer submitted digitally altered false documents, which the court found sustained a fraud penalty. Yeah, faking the documents, generally not a good idea on an IRS exam, but, well, she took the risk and didn't work out well. We also have the IRS updating the Section 530 employment tax liability relief guidance. Now, that is not Section 530 of the code, but rather Section 530 of the 78 Revenue Act. We've got it inside the materials and inside the notes, so we'll leave it there. That deals with the potential relief if the taxpayer attempts to reclassify individuals that the employer had been treating as independent contractors, tries to reclassify them as employees. This can provide for some relief. So with that, let's go first off to the IRS grant of relief to wildfire victims. This came out on January the 10th on Friday. It's IRS News Release 2025-10. Entitled IRS California Wildfire Victims Qualify for Tax Relief, Various Deadlines Postponed to October 15th. Now, as it says, basically this notice, this news release, tells us about the various filing obligations for those that have been involved in those horrendous wildfire situation in Los Angeles area. This will get a postponement of payment deadlines to October 15th of 2025 for those who live in the disaster area. Currently, it would be those who reside or have a business in Los Angeles County qualify for the relief. However, if in fact the taxpayers in other counties, if other counties are added to the disaster area, those other taxpayers would qualify for that. List of the current counties is maintained in cases like this on the IRS's website. So you want to be sure you double check if you have a client outside of Los Angeles County, but potentially inside, in an area that may be affected by these wildfires, which as I record this on Sunday, things are still not under control. So we're keeping an eye on what's going on over there right now in the whole situation. Tax preparers who are in that area, but are located outside the disaster, but who have clients located outside the disaster area. So you're a tax preparer, you are in Los Angeles County, right, is where you're at, but you have clients located outside of Los Angeles County. Obviously, if your office is now non-existent, you definitely may have trouble getting things done in tax season. Those taxpayers, there is a method on the IRS website that describes how they can get bulk requests basically for relief for their clients by going through what's on the website. So we'll take a look at that. Now remember, it's not necessarily going to be the case that other states are going to grant relief as well. And at least technically, we're still waiting on the Franchise Tax Board to tell us what sort of relief they would grant. Obviously, at the moment, there are probably more important things that they are kind of working up on that. But it is, at least as a basics, probably I'm going to think the Franchise Tax Board is going ahead with this. And what we're going to see is something at least as generous, if not more so. The tax relief postpones filing and payment deadlines that had occurred from January 7th of 2025 through October 15th. So basically, that's the range where things are impacted. That does mean, for instance, things like if you have a filing deadline on January the 15th, you have a fiscal year taxpayer with a January 15th filing deadline, had like an October 15th deadline or an October 31st year end, January 15th. Let's see, actually it should be September 30th year in this C Corp. But anyway, you had that filing deadline that's going to be January 15th. It now gets pushed all the way forward till October 15th of 2025. We'll go through those deadlines. Okay. Now, in addition to any tax return with a deadline in that range, and again, any tax return that has a due date within that range, federal return, is automatically kicked to October 15th as its due date. So you're going to buy yourself relief to what's the normal extended due date. Except remember that in this case, anyone who's affected by this, covered by this ruling, a return that is filed on October 15th will be treated as if it was filed on the original due date. That can make some key differences, some interesting issues, and also for interest payments on refunds has impacts. So keep that in mind. Unfortunately, those in California will probably be very, very familiar with most of those rules, since it wasn't that long ago that we had virtually the entire state of California under some sort of, disaster relief provision, this time for flooding, and other things. So yeah, we had various things happen. But that will include other things. Other deadlines are also pushed back. For instance, contributions to IRAs and health savings accounts would normally be due on April 15th. Those can go in as late as October 15th to 25. They'll be treated as if they went in on April the 15th. Quarterly estimated tax payments normally due on January 15th. And estimated tax payments normally due on April 15th, June 16th, and September 15th of 2025. Those due dates for those payments will all move to October 15th to 25. Penalties for failing to make payroll and excise tax deposits due on or after January 7th and before the 22nd of January will be abated so long as the deposits are made by January 22nd. Now, this one, especially since the situation appeared to be maybe improving on Friday, then the weekend came, and certainly, there are still many, many areas of concern with what's going on over there. We'll see if this one gets expanded. This one I could see an additional change on here, so I'd keep an eye out for the due dates for payroll tax deposits, because it's not really done yet, is kind of how this is going. So we're going to keep an eye on what happens there. The IRS also reminded you in this ruling about some additional tax relief. Not really something that's created by the ruling, but this is just general purpose ideas. Remember that taxpayers who suffer uninsured or unreimbursed disaster-related losses can choose to claim them either on the 25 or the 24 return. Obviously, claiming on a 24 return, could get you access to refunds quicker than claiming on 25. But if for some reason your 25 income is going to be higher, then obviously it might be better to have it on 25 return. You have a choice, either one. The loss obviously took place in 25, but you can go back to the prior year for that. Qualified disaster relief payments are generally excludable from gross income. And also, there is special retirement plan relief. Remember, this was an addition made to the law. This was with Secure 2.0, put this one in. But open up a general disaster relief issue for qualified plans. So if you are in a retirement plan or an IRA, you may be able to take a special disaster distribution that would not be subject to additional 10% early distribution tax. Also be allowed to spread the income over 3 years. So remember, those rules are also in place for the moment, at least. And this is probably something not that if you have a client who's been impacted directly by this, that's probably not their instantaneous issue, is thinking about these things, but it is something you're going to be talking with them during the year as it comes up. Next up, this is the time of year that we get the National Taxpayer Advocates report to Congress and their Purple Book with legislative change recommendations. They put this on their website on January the 8th. Now, the key findings of the annual report for last year. First thing is they discuss the issue of the need for an improved taxpayer experience. Right, so when we talk about that, we're looking at the improved taxpayer experience routine. In that particular case, we have this issue. For the first time since 2020, they reported an improvement in taxpayer experience. The backlog of returns has gone down. That's nice, because we've had a big issue with that. They've also made progress in correspondence during the pandemic. Generally, they receive timely refund and shorter wait times to reach customer service. So those are both considered good things. The Taxpayer Advocate has criticized the allocation of IRS funding from the Inflation Reduction Act. Majority of the fund, 58%, was allocated to enforcement. Only 4% was allocated to taxpayer services. The Taxpayer Advocate believes that Congress should change that allocation. Obviously, there's a lot of questions about that funding anyway, but nevertheless, that was part of what they did. Also, we got there, we have tax-related scams involved too. There's been a big kick up in there. The scam reporting process, she noted, is confusing, and the IRS should encourage taxpayers to come forward and share information about these scams they've observed. Yeah, you got to watch for a lot of scam issues going on, unfortunately, these days in that area. She also was concerned about the lack of tax and financial literacy among the population. The IRS needs to improve this. That includes, making some of these issues to improve their graphics, explain the tax system, how the government uses tax revenue. And also they the Congress amend Section 9703 of Title 20 to include promotion of tax literacy among the duties of the Financial Literacy and Education Committee. She also noted some issues with civil penalty administration, right? The IRS is civil penalty administration. The folks have shifted away from using penalties solely to encourage voluntary compliance. It's now, she believes now is the time to reconsider the existing penalty regime and develop better information on how penalties affect taxpayer behavior, right? There is a concern that she has that the numerous penalty provisions have been enacted do not achieve the goal of encouraging voluntary compliance. And also, she cites research that indicates that penalties should be administered in a way that is responsive, reasonable, and reproducible. Not necessarily how it's working in this case. The report also lists the most litigated issues that we have here. That included collection due process hearings. Relatively small number of taxpayers exercise their rights administrative reviews. Other areas included the litigation on foreign bank account reporting, FBAR penalties. There are circuit splits on how those are involved, and challenges concerning the Administrative Procedures Act. Got a lot of APA stuff. Probably going to have more. The Taxpayer Advocate Service itself has seen a significant increase in cases, right? They received actually 257,000 new cases in 2024, a 17% increase in 23. That's, one of those key issues going in. And she also continues to worry about concerns about delays with the employee retention credit delays. That backlog is still pending as of October 26th of 2024. When she took a look at it, that includes some that were many who've been out there for over a year and that impact on businesses. She suggests that they need to be doing something more in that area. Right? She also took a look at the 10 most serious problems, right, that she sees has been out there, what they find in that area. Those serious problems that she noted include that issues that include her 10 most litigated problems include some of the things already discussed, but the employee retention credit, delays in return processing, tax-related ID theft, taxpayer service, scams, IRS challenges in hiring, processing individual taxpayer identification numbers, and again, tax and financial literacy, civil penalties, and criminal voluntary disclosure programs. The most litigated issues that she found also noted those, and she has that list is also in her report. So we have all of those things coming up together. Now, the Purple Book has legislative recommendations, right? These are changes that she wants to see in the law. Those changes include some sort of litigation allowing the IRS to regulate tax preparers to assure the preparers have base competency. Okay, that's not one I see as likely to get passed, but she's pushing it by noting that apparently there are a lot of not necessarily the greatest preparers out there, and that it would be better. This one is mainly kind of I guess, to emphasize the importance move. It sounds good, this sort of thing Congress might do just because it's simple. She suggests that the Taxpayer Bill of Rights be moved out of Internal Revenue Code Section 7803A3 and be made the new Section 1 of the code. That'll foul up some cross-referencing, but basically the point is to make it important that those rights are front and center in the code. I could see Congress doing it. I'm not sure it would change anything, but it sounds good. So, we'll kind of do that. Now, she also wants a power for the Taxpayer Advocate Office so that they could have access to information, right? Modify Section 7803C to clarify that they have the right to participate in meetings between taxpayers and the IRS and to access tax returns and tax information. Currently, the problem is that privacy rules, it's not clear that TAS really has a right to be involved in any of those. That complicates matters and makes it a little bit messier. She also wants the agency to have the right to file amicus briefs in federal tax cases to share their views with the courts. Those are the friend of the court petitions that are filed currently. They don't have that authorization to submit such briefs in litigation. They need to stay out of it. Under current law, the rule would prevent them getting there. She thinks they should be allowed to go in there. Several recommendations she has for penalty administration. One recommendation calls for clarifying the supervisory approvals required under 6751B before proposing penalties. There's been a lot of back and forth. We know it's required. The catch is what's adequate, what's not. Some clarifications there. She also recommended that the assessable penalties be subjected to deficiency procedures. With regard to ITIN assistance, she recommends that the Congress authorize use of VITA grant funding to assist taxpayers with applications for individual tax identification numbers when necessary. She also recommends that the law be changed to expand the time period, request a collection due process hearing, and file a petition challenging a notice of termination in the tax court. When it comes to IRS issuing third-party contact notices to taxpayers, she believes that the law should be changed to require the IRS to specify the information needed when issuing those notices to taxpayers. Also looking for modifications to innocent spouse relief. She suggests that taxpayers may raise innocent spouse relief as a defense in collection, bankruptcy, and refund cases. The Congress should clarify there. And she also is asking for an expansion of the tax court's jurisdiction, right? To allow them to hear refund cases. Currently, they can't. If you're suing for a refund, like let's say an ERC refund, you're not allowed to take the case there, right? Now, if the IRS is coming back to collect money from you after they refund you the money, then you can get there. But if the IRS has disallowed your claim for refund, any litigation has to take place inside of the U.S. District Court system, which is a more expensive, complicated system. She would prefer that this be allowed in the tax court. And she also would like to have them determine overpayments by non-filers who have filing extensions, that they could make those determinations. So that's her report. It's available for download if you want the whole thing. Both the Purple Book and the report are both on the Taxpayer Advocate's website and available. Next up, well, this is kind of so a little repetitive, but we'll tell you about it. This is a case of Smith et al. Versus U.S. Department of the Treasury, case number 6:24CV00336 from the U.S. District Court for the Eastern District of Texas. This one came down January 7. This is now the fifth or sixth, it depends upon how you're counting, U.S. District Court to rule on the validity of the Corporate Transparency Act. And if you use the sixth court count, because there is one case in Michigan that's kind of like the others, and did conclude that they were not likely to win on the merits. So presumably you're going to say that therefore it had to be constitutional. At least that's the presumption they're coming onto, at least for this purpose. This is like there's now a nice perfect split, right? 3 and 3. Okay. Now, this was the injunction. Corporate Transparency Act implementing rules are likely unconstitutional, right? They found that like the other cases, these cases, whichever side they're on, if they're saying it is or isn't, the opinions tend to read very similarly, right? The only one really different was Community Association's opinion, because it went into their separate argument over whether they should have been seen as a tax-exempt organization, whether HOAs and the like should be seen as that. So that's the only real one that has some additional discussion, shall we say, that goes a bit beyond this, right? So they found that the CTA likely exceeds the authority. Again, didn't regulate it does not regulate the channels or instrumentalities of interstate commerce, because you don't have to be doing anything in interstate commerce to be covered by it, right? So, and it doesn't regulate activities substantially affecting interstate commerce. Now, if you go read the other opinions, you'll get the exact opposite ruling, saying all three of these, they say exactly the opposite. So again, like I said, it gets repetitive in a while. So we're there, but still, this is here. It didn't, it does, they complain, it didn't limit its jurisdiction just to those participating in interstate commerce or foreign commerce, which they claim is fatal to it. They thought congressional findings justify it were insufficient to demonstrate the CTA fills an essential gap in a broader regulatory scheme of economic activity. Also found the link between the activity and commerce is too attenuated. We like that word, right? Too far afield, shall we say. In this case, not linked enough. And it's not a necessary and proper exercise of Congress's power to regulate foreign commerce, because it does not regulate foreign trade or commerce itself, nor does it regulate the channels or instrumentalities of foreign commerce. So saying all of those are reasons why it shouldn't be succeeded, right? So essentially, that was it. Determined CTA is not, as we said, necessary for that. And we have this also not a taxing power, right? They found the harm to the individuals was irreparable if they had to comply with unconstitutional law. In that ruling, determined the incurring the undercover cost compliance with federal law also is irreparable harm. The feds aren't going to repay them for the time and effort involved in complying with the CTA filings. And it also determined disclosure of private information type of harm that cannot be undone through monetary remedies. So they're saying, so we are going to issue this imbalance. And also found the balance of the equities and the public interest leans in favor of granting this particular relief to the taxpayer. The injuries likely to occur without an injunction outweigh any harm in granting it. It reasons public interest is not harmed by preventing the enforcement of unconstitutional laws and unlawful rules. As you may guess, the other side cases, in this case, the other arguments, will then flip it and say, no, 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 the public's harmed by, not regulating illegal activity. This is kind of back and forth. And as I say, to a certain extent, this case is a sideshow because we know where the real work is. We'll discuss that right at the end of this. The big thing, which is happening right now, we need to be aware of, but that was okay. This one, though, was ahead of time. So as expected, they ruled that we should issue the injunction, right? Now, the interesting part here, they did enjoin the department from enforcing the Corporate Transparency Act against the plaintiffs and their related entities. And this part is protective of the plaintiffs in this case. Remember, one of the things that the feds are asking is that the injunction at least be knocked down for, the one that applies nationwide to everybody, including those who are not plaintiffs in this case. The court says, essentially, they even kind of admit that this is coming out because it's unclear what the Supreme Court's going to do. And there's a possibility that, they're currently covered by the broad injunction from Texas Top Cop Shop. But if that's struck down, they would lose that protection. So now they're going to give them effectively the protection that we had in the Alabama case, where the plaintiffs would get the protection, something which the Supreme Court, and I think this is part of the reason this is out, I think there is some concern. The Supreme Court likes doing these type of intermediate fixes, and they could very well just knock down the national order, largely because a lot of the justices have written at various times, complaining about local courts overturning, doing nationwide, any one of the 600 judges deciding to do a nationwide ban. So this covers that. It also, though, still does do a nationwide ban, too. And this is really, really interesting protective thinking. Well, because the other injunction was nationwide on everything. So there's concern the Supreme Court will just knock that down in whole. So now this one takes a subset of that injunction and looks at a portion that found the setting of the effective date for the reporting rule violates the Corporate Transparency or violates the Administrative Procedures Act. And we hadn't seen many APA attacks here because, for the most part, they were following exactly what Congress wrote in the uncodified portion of the law. But this brings up an APA because APA does provide authorities for local courts to delay a rule, right? To put an injunction if they didn't follow proper procedures in coming up with their effective date. Now, this part of the case is interesting because it's coming up more. We also saw it, as I'll mention here in just a second, we also saw it in, and I should, I guess, mention right now, in the big thing that happened this week, which is we did receive the answer from Texas Top Cop Shop and the other plaintiffs in their case, basically answering what the U.S. Justice Department had filed with the Supreme Court. Their answer to that in opposition to removing the injunction, right, and taking it away. And they spend time now, suddenly in their brief this time, I began to notice more emphasis on this Title V USC 705, the Administrative Procedures Act, side of this. I'm thinking that there is concern that, Supreme Court is not happy about all of these, blocking everything from the top, especially blocking laws passed by Congress. So they're now going to develop the APA argument. So this is just an agency action. Of course, as a practical matter, I think at best you get a 1-year delay. If I remember, under the APA, Congress gave the agency the right to set the effective date, but it had to be on or before, no later than January 1st of 25, which would then mean the filing deadline, January 1st, 26, whatever. Under that structure, so that would be a minor that'd be a minor one if gotten, but still interesting. Now, as I said, we did get the answer, and that's where the real issue is coming up. The Supreme Court now had their, had the filing from the Justice Department. We now have the answer that came back from Texas Top Cop Shop, etc. We've had a ton of amicus briefs. I gave up counting them after a while on Friday. We were up to at least 12, and more came in later. So, we're up to quite a few amicus briefs in the case. We'll just have to see how quickly the Supreme Court acts on this. Friday, they were tied up with this, this whole TikTok thing. So we still have, they're still waiting on this part. But I expect the Supreme Court ruling to be the key. Obviously, there are various things the court could do. They could tell Justice Department, nope, just got to wait on the Fifth Circuit. They could actually decide to rule on the underlying case, which would be nice, but I don't think is likely. It'd be great for the Supreme Court to do that because they're where this will ultimately end up, I think, without doubt, but they don't like to step in too early. If it can be decided by the Circuit Courts of Appeals, if they all can come to a consistent answer, they like to let it go. They know there are at least two opinions coming from the Fifth and the 11th Circuit. So, they may want to see those two and then decide what they want to do. So the other part is, though, they may take care of just the injunction. And they may decide to, as I said, the Catch B, knock down the nationwide injunction. But then we immediately have this one come up unless they also basically deal with the Administrative Procedures Act and decide if that would be a valid part of the injunction. And they could then modify the injunction to only, to go ahead and still bar the effective date under 5 U.S.C. Section 705. Yeah. In essence, I'd keep an eye on the Supreme Court, is what I'm saying currently. That's where we're likely to see things. But there is this case, and keep this in mind because the Administrative Procedures Act, injunction here, the APA injunction, which is, not as broad as the nationwide injunction that the Texas Stop Cop Shop case had issued, that could complicate matters. So keep an eye on what goes on. It could make it a little messy. Okay. Next up, we have a certified historic structure ruling from the tax court. This is a case where the tax court, in the case of Capital Places 2 owner LLC et al. Versus Commissioner. This is a reported tax court case, 164 TC number 1. First reported tax case of the year, coming out on the first day the tax court was open, January 2nd. So we actually have this right away. We went to a reported case. Now, this case is going to deal with a charitable contribution of a facade easement to a historical preservation organization. The question becomes, was it a qualified conservation contribution under Section 170H of the Code? Generally, you cannot claim a deduction for a charitable contribution if you only give a partial interest, right? You don't give all of your rights in what you gave the charity, but rather you only give a limited subset that normally is not considered a charitable contribution under the code. There are, however, some exceptions, one of which is if you have a qualified conservation contribution, and one of those comes in that category is is basically a historical facade easement, can qualify under those rules. So we're going to want to talk about what they do and whether what was given here actually qualified. Now, in December of 2014, CP2, that's what they referred to it in the case, the plaintiff donated a facade easement over the Manson building, an early 20th century structure located in a historic district of Columbia, South Carolina. So this is a building in a historic district, right? Identified historic district of Columbia, South Carolina. Now, they claim this facade was basically, the easement was worth nearly $24 million, and they claimed that on their 2014 return. Okay. Now, that building in question, it was described as an early 20th century building located in a historic district, which, we're there. The deed stated the building was a contributing resource of the Columbia Commercial Historic District, which was listed in the National Register of Historic Places in 2014. And so it's important to note that it was in that district. Now, the deed, though, is what states that this was a contributing resource, right? Important building in that area. We don't have any government saying, any government agency saying that, or the Department of the Interior saying it. We just have it from here. And the building itself was not individually listed in the National Register. It just happened to be in the historic district, right? Now, the easement deed, it specifically is limited to the building, facade, and development rights. The stated purpose was to ensure the facade was retained and maintain its rehabilitative condition exclusively for conservation and preservation purposes. Okay. It also specified that the easement was intended for the scenic, cultural, and historic enjoyment of the general public and to prevent changes inconsistent with the building's historical character. All of those things. Now, the IRS argued the donation itself was not a qualified conservation contribution. And they said the big issue was this is not a certified historic structure. Remember, we've got to meet one of the categories to allow this partial contribution to work, and this easement, we're trying to get it in under the certified historic structure rules, right? To qualify, a building must either be listed in the National Register or, and we know it's not there, or be located in the Registered Historic District, it is that, and certified by the Secretary of the Interior as historically significant to the district. The second clause there is going to be our issue, right? It's located in the district. There's no question about that. But yeah, we have a little problem here. The building itself, not in the register, so we can't get into the first route. Everybody agrees it's not in there. Nobody disputes. This building itself has never been listed there. The IRS stated, and the plaintiffs never came up, or I should say, the taxpayer didn't come up with an alternative. They never, Secretary of the Interior had never certified the building as being of historical significance to the district. Essentially, that doesn't exist. It's not there. Right. Also argued that the deed did not protect a historically important land area, right? That was one of the issues. The IRS noted that the taxpayer, could not unilaterally amend or, alter or amend the for conservation purposes listed in deed after the fact. So that was fine for them. And the core of the case divides a qualified contribution, which says for its requirement for a charitable contribution related to such a contribution, right? And 170H1C requires that a qualified contribution be exclusive for conservation purposes. 170H4 defines conservation purposes, and the court specifically analyzed two of the categories that can be conservation purposes, could qualify. First, 170H4A IV. This provides a conservation purposes protection of a historically important land area. That's one option. And as we said in that particular background, and then HC defines certified historic structure, which is the focus of the court's analysis. It states a certified historic structure includes any building, structure, or land area which is listed in the National Register. This one's not. Or any building which is located in a registered historic district and is certified by the Secretary of the Interior to the Secretary of the Treasury as being of historical significance to the district. Those are the ways in. Now, the IRS says very simply, they haven't done either, right? It's not going to meet either criteria. It didn't qualify as a certified historic structure per the court, right? Listing in the National Register, the court noted the building was not itself in the register, but the district was. So merely having, now the question becomes, is it good enough to have the building in the district? It says no. They said if in fact the district, just being a district by itself was good enough, then there wouldn't really have been any reason for the language of the statute. And the plain language of the statute requires the building to be listed, not just a district in which it is located be listed. In essence, why did they, kind of miss that? You list the building. It didn't say it could be one simply by being in the historic district, right? And for the second category, if it's in this district and it's not in the register, but it's certified to be of historic significance, then it could. But the problem there was it was undisputed that they made no written application to the Secretary of the Interior for such certification. There's no evidence such certification was ever made. They just had kind of the self-statement in the deed stating that it was significant. And the court's not going to worry about whether it is or isn't. The court says the law requires the Secretary of the Interior to make this call, and he didn't. It did not protect a historically important land area, had not demonstrated the deed language protect an area of historical importance because they didn't meet any of those criteria. They also noted that its readings of historically important land area would swallow the more specific definition of a certified historic structure. If you didn't really need to have a certified historic structure, if we just use, historically important land area, in theory, a building is always going to be on land. So the theory being that would just duplicate. As long as you were within something that was identified as historically important land area, all the buildings there would qualify. And they said Congress didn't go that route. They decided to put in secondary requirements, and this building didn't meet any of those secondary requirements. Right? So because of that, right? That found both problems, so they ended up losing that. Right? So that's there. Again, reported case because this particular issue of whether you could kind of backdoor the building in without the Secretary of the Interior had ever been really discussed. So that's why they show this as a brand new case. Next up, let's talk about method of accounting and how an attempt by the taxpayer to protect their interests in an exam effectively ended up backfiring, or maybe backfired. We don't know. Because one thing we're going to find out here, the important thing about this case, which is Bank United, Inc. versus United States, U.S. District Court, Southern District of Florida, case number 1:23-CV-2039, that came down on January 7th, 2025, is the court will never make a determination as to whether this was a method of accounting or it was an error. Because the problem is they're going to argue under duty of consistency that the taxpayer was blocked from attempting to benefit from taking the position that this was a method of accounting. Right? They're kind of blocked. Now, this case deals with the issues of whether something is a method of accounting or an error. Okay, methods of accounting deal with the timing, but not the amounts of a deduction or an item of deduction or income. It's not, so for instance, a simple example. Let's say that your company had been, every time you bought a building, you wrote off the entire building the first year you got it. That would be a method of accounting. And as I said, we're going to be able to eventually write off a building through depreciation. But that's an improper method because under current law, basically you would have to recover that building over the appropriate period of years. But that would be a method, right? An error would be recording the depreciation, not only expensing the building, but then recording the depreciation in later years. That would be considered to be an error of sorts, doing double counting or doing other things or taking a deduction, maybe taking a tax credit that you weren't really eligible for, taking a deduction. Yeah, things like that are errors. It's an error. It's not something that would be recoverable in general. It's just a simple error. Now, generally, the big difference is methods of accounting. You need the IRS permission to change them, even if they're wrong. But when you change them, we make a cumulative catch-up adjustment under 481A, which means effectively, we don't worry about the fact you claimed the wrong numbers in prior years. Let's say if you'd written off that building. We don't care that in the prior years, you had not paid tax in earlier years because you wrote off the building, right? Assuming the IRS comes in, the IRS doesn't come in until we're more than 3 years past that date. You didn't do it fraudulently. So that's not the problem. We're still going to go back and force you to add back to income the amount of cost that you should not have yet have recovered as of the first day of the first open year, when the IRS would force a change of accounting. Or if you voluntarily moved for the change of accounting, it would be in the year that you asked for and received permission to do so. That would be your structure. That would be the way it would go. Errors are done by amended returns. You do an amended return. And more importantly, for an error, if the statute closes and the IRS never examined the return, those funds are beyond catch. So that's the concept of an error. But as we'll discover, there is a theory called duty of consistency that can cause you problems with errors. Okay? And that is the other thing we're talking about here today is this covered by the duty of consistency doctrine? Okay? The case involves 597, which itself is not of widespread use. We're going to basically talk about this very briefly. The facts here involved uncertainty over whether the assets should have been included as Class 1 or Class 2 assets. Certain assets that were part of a subsidiary of the bank that was being acquired, whether or not they should have been considered part of the assets acquired under 597, which has special rules for recognizing income when you acquire the assets of the bank, and especially when you pay less than the fair market value of those assets. That's going to be kind of one of the things you're looking at there, whether you have to then pick up income in later years. If you end up getting, how you pick up income in later years as you recover that, or the guarantees go away, you get paid guarantees. So we look at that. So they include a broad class of loans in those assets. So the purchase price was less than the fair market value of all the assets that they had received in that case, right? Okay, now, however, if many of those loans should never have been there, then the purchase price would have been more than the fair market value of such assets. And in that case, there is no 597 income. Now, the question becomes, should those assets have been counted? The taxpayer had assumed they should have. They're reporting 597 income. However, on exam, it began to become clear to them that there might be an issue regarding maybe they shouldn't have been included, in which case then they should never reported 597 income. Okay, that's it, right? So again, as we said, the bank initially took that position and they recognized a gain under 597 from 2009 to 2014 on returns. A later IRS exam took place when 2012 and later years were open for refund claims. And more to the point here is 2012 statute of limitations for filing a refund claim was about to expire, right? It was coming up to expire shortly. Okay, so as part of that exam, they filed a claim for refund because they're trying to preserve 2012 in case the IRS decided that, they shouldn't have had 597 income in that year. Now, as I said, if this was a method of counting those assets in or not, then you wouldn't have had really a claim for refund in 2012. A taxpayer cannot retroactively get that fixed. They would have to get it fixed going forward, right? The IRS could allow them a change of method, but it would be in the first year that hadn't yet been filed, right? A 3115, and if it's not automatic change, they would have to get IRS permission, so it may take a while to get that. But if it's an error, if they simply just made an error, right? An error, it was an accounting method, and in this case, it gets really, really weird trying to figure out which one it is. Then they need to claim for refund. So they told the IRS, we're going to do this claim for refund. We're putting it on the table that it could be an accounting method, it could be an error. But if it's an error, if you believe this is wrong, if it's an error, then we want the money back from 12, right? Okay. The IRS allowed that claim for 12, made adjustments for 13 and 14. They issued refunds of just under $290 million plus interest. So significant money. Right? We had that, right? They didn't issue refunds for 2009, 2010, or 2011. The statute of limitations for those years had expired, but they obviously had reported that income in those years and presumably had hundreds of millions, right? At least a couple hundred million, arguably it would appear, of, taxes paid that now they're going to get no benefit from, right? It's right there if it was an error. Remember, those refunds only make sense if this was an error and not a method of accounting. Okay? The IRS had taken the action that they had requested if the treatment was an erroneous treatment. That's the key thing to remember. They had done that and they had protected. Again, they ended up getting that refund, which they would have lost at least the 2012 portion of, right, going forward. In 2019, they filed an amended return claiming a $1,104,000, $2,063 independent capitalized asset, which they were wanted to write off, right? Now that says they want to now treat it as a method of accounting to allow deductions to help offset the taxes they had paid in those earlier years. And what they had done, they'd taken the amount in question that they had capitalized, they reduced it by the refunds and others. So there were various adjustments they made, but they're now trying to write that thing off. That, remember, they got a refund based on the theory it never should have been capitalized. Okay. Now, they conceded the refund request stemmed from the classification of failed bank for 2008, 9, and 10 for those years, and that, and they couldn't recover the taxes paid in those years. But they're saying, oh, but it's a method of accounting. We're just going to do the improper method. Well, this one became a little more interesting. The court found that it did not need to decide if this was a method of accounting or an error matter, as the taxpayer had already conceded it was an error under what's called the duty of consistency doctrine. Generally, it's triggered when three things are met. It applies when there is a representation or report by the taxpayer on which the IRS has relied, and an attempt by the taxpayer after the statute of limitation has run. Remember, 2012, everything closed out. This was, basically now in 2019, they finally tried to write this thing off to change the previous representation, to recharacterize the situation in such a way as to harm the commissioner. Now, there's no question that the statute had run out. And the question was there a representation that the IRS had relied upon? The taxpayer obviously is going to claim, no. But the court said, wait, you can't ask the IRS to decide this issue. When they decided and sent you the check, you accepted the check, right? In essence, you essentially now are accepting the IRS position, right? Because now they're saying, so if this test is missed, the IRS may act as if the previous representation on which the tax relied continue to be true, even if it's not. So even if this is a method of accounting, no question, the IRS relied upon their benefit from treating it as an error, right? They treated it as an error, the IRS did this. Their letter requesting a refund on 2012 before the statute expired met the test. This is the problem. To protect themselves on exam, they took this step. They didn't say, hey, it's a method of accounting. We're going to apply for a method change in 2015, right? By the way, that would have been a high-risk strategy because the IRS could have fought then over whether it's an accounting method or an error. And as you're fighting over this, you're losing refund time. So you would have maybe had to do a protective claim, filed this, but say in the alternative, we would go for a protective claim in case we lose on that. But they didn't do that. They went the other way. They stated that the I get this right, $1,946,945,094 of phantom basis assigned to captive REITs loans may be viewed as giving rise to an improper method of accounting or series of errors, right? So they agreed it could be either. Also stated that they requested the IRS determine whether it was entitled to a correction for its previous treatment of the captive loans and whether this correction would be made under the accounting method change procedures or by way of amending the prior tax returns. And if we're going to amend the return, send us money back, right? Okay, that was kind of the The court noted that after receiving this request, the IRS found BUI improperly classified as Class 1 asset and issued them the refunds for the overpaid, for the 597 income for those years. But again, if that was an accounting method, that wasn't what they should have gotten. As an accounting method, they should have been required to ask for permission to change it, and then the service would have, basically had that take effect under the 41A adjustment rules. But that's not what they did. They cashed the check, right? The court noted the IRS relied on the assertion that BUI had made an error when it issued the refund, because they gave it to the IRS, said, just tell us which one this is. And when the IRS said, we think it's an error, we issued a $209 million refund check that it doesn't work unless it's an error. You effectively took the position it was an error. You didn't hold your ground and say, hey, this is a change of accounting method, and we need to be able to go down this path of accounting method change. It needs to be that path. You didn't decide to fight for it, but you also accepted the theory that it was a error because that got you a refund right away that you wouldn't have gotten, unless it was a change of method. So we're kind of going down that path. Because it requested, IRS determined if it was entitled to correction because the IRS granted it a refund based on that assertion. It could not now argue that it followed the regulation under 597 and had a method of accounting. Therefore, no refund, guys. Tough luck. You have a couple of fraud cases here. This is kind of interesting. Just go over from a fraud standpoint. This is Bachner versus Commissioner. The factual background of this case is the taxpayers filed joint returns for 2005, 2007. During those years, Edward engaged in a scheme to fraudulently inflate his income. He overreported his earnings and overreported withholdings. That resulted in refunds, because if you have high enough withholdings, it doesn't matter how much income, right? You're going to get a refund. You're going to increase your refund, which is what he did. In addition, he illegally obtained a dangerous substance and fraudulently procured a life insurance policy. He got federally criminal charge on those, along with the tax issues, right? He pled guilty to making a false claim to the IRS for 2005, possessing of biological agents for use as a weapon, and wire fraud. Yeah, he had a bad day in court, shall we say, at that point. As part of a plea agreement, at least, he admitted to submitting false refund claims for 2006, 2007 as well. Those were all conceded in his agreement. He did serve 7 years in federal prison as part of this. Okay? Now, upon his release, the IRS was waiting with a notice of deficiency for 2005, 2007. And they're looking for the 75% civil fraud penalty under 6063 of the Revenue Code. So they're looking for a total of $393,807 in penalties, plus the actual withholding, which of course would be 1/3 more than that amount that he did. So the taxes that he basically the refunds in excess of what he should have received, he had received. They're asking for all of that being paid up. Now we're going to fight over whether, really they should be considered a fraud. Is this a fraud? And they challenged this notice in tax court, which ruled against them. They're saying, look, we in fact overpaid our taxes. We just overstayed our withholdings, right? We pay because the actual tax on the return is way in excess of the total tax they would have owed. Of course, they claimed all these withholdings that never took place, which is how they ended up with getting these big refunds, because the IRS issued the refund checks, never noticed, it took a while for the IRS to notice that the withholdings didn't work. We all know that kind of is how the system works. So they said, hey, you can't go after the fraud penalty because that requires an underpayment of tax, an underpayment. So first thing is it argued notice of deficiency was invalid, there's only identified penalties and not a deficiency. First thing is the court dealt with this. They also got a statute of limitation that expired, and the notice was improperly included Rebecca, because she was covered by instant spouse. They also argued they did not underpay taxes, but received excess refunds. They said it couldn't be liable for fraud arising from underpayment of taxes because he hadn't underpaid the taxes. He just over-received refunds, right? And the tax court had no jurisdiction because there was no deficiency. The problem is overstating withholdings, turns out, does actually count under the language of the code as being part of this, right? Right. So they looked at whether the tax court could apply the fraud penalties. They looked at the evidentiary issues for false returns under their assertion of privilege against self-incrimination. And what the court ended up looking at this in an analysis, it said that Edward had standing because he was already directly indicted. For some reason, they'd include his wife, who's out innocent spouse. So they got rid of her from the case. That's just a technicality at this point, right? The tax court had jurisdiction. There was explained that penalties are treated the same as taxes under 6065 of the code for the tax court's issues. So they're saying, therefore, there was jurisdiction in this case. So basically, that was part of it too. They could file for that. The underpayment, they rejected their argument that they did not underpay their taxes. They noted that under the Treasury Reg 1.6664-2C1, the amount of tax reported is reduced by the excess of the withholdings reported that over the amount actually withheld. So therefore, their taxes were less than they should have reported due to the excess withholdings. And by overstating withholdings, he created an underpayment, and therefore the penalty could apply. That's how this one worked, right? It dismissed remaining arguments, including contention and no sufficiency was invalid because it included Rebecca's name. Also held there was no evidence of bias by the tax court, and the assertion of privilege against self-incrimination was properly overruled in this case. And they affirmed the tax court decision, upheld the fraud penalties against Edward Bachner. Okay. Now we have a second case of somebody with a fraud penalty. This case came from Tax Court Memo Decision 2025-2. And this one is Veen versus Veen K. Chopra versus Commissioner. On January the 8th, this is TC Memo 2025-2. There was a $30,520 deficiency and then a civil fraud penalty, getting the 75% civil fraud penalty of $22,890 was in the mix. The facts of the case, Chopra, a healthcare consultant with advanced degrees, filed a 2019 tax return, reported $188,015 in wages from her employment on her W-2. She also claimed significant losses from a consulting activity she was involved in on Schedule C, and her participation in a partnership, Manticore Consultancy, on Schedule E. She claimed a total of just under $90,000 in business expenses, an itemized deduction that included $69,000 in medical expenses and $27,000 of state taxes, both of which were reduced by limitations. Okay, in that background, that's going on. Now, her return was selected by the IRS for exam, and she provided credit card statements for 5 non-consecutive months, which showed inconsistencies. Like these statements showed things out of date order, which is not normally how this works, and there were other problems with the documents, right? She also submitted various documents, including hotel receipts and invoices that appeared altered or suspicious. For example, she had hotel receipts that misspelled the hotel's name. She misspelled Marriott, right? It had it misspelled, and at extremely late checkout times, one of which was after 11 p.m. in the evening, right, of the day she supposedly would left the hotel, and she was charged only for the night before. Again, misspellings, all these look bad, things were missing, charges weren't there, taxes that you would have expected to be on a hotel bill were missing. In essence, it looked totally fraudulent, and we only had 5 months of these credit card statements, right? She had invoice from legal services from a law firm that were basically disavowed by the firm when contacted by the IRS. They didn't issue those invoices, right? They weren't there, that she had them. And she had a purported invoice from United Healthcare for a $68,977 medical bill that was found to be fraudulent. Johns Hopkins Hospital had no record of her treatment. She claimed a deduction based on that disallowance by United Healthcare, and there were other problems with the United Healthcare notice of disallowance. It just didn't make sense. There were a lot of problems with her documents, to put it mildly, right? She was uncooperative during the exam. She failed to provide additional documents when requested, and she did not respond to IRS attempts at communication. She also refused to provide tax returns or documents related to the partnership. Ordered to produce these records, she responded that the additional financial records were irrelevant and that the Manticore tax return was confidential. So we can't show that to you. Okay, that's not going well for her in this case. The court noted that the commissioner's determination and no sufficiency are generally presumed correct, and she bore the burden of proof. She did not cooperate, so she didn't shift the burden, right? There are substantiation requirements for all deductions. The taxpayer must keep books and records that substantiate the expenses, and the failure to keep and present such records counts heavily against the taxpayer's proof, or it can actually kill it for things that require, like 274D, that are mandatory documentation requirements. It cited 162A, which allows deduction for ordinary necessary expenses of carrying on a business. It said to be necessary, it must be connected to and help the taxpayer's business. It turns out that her consulting Well, her theory for that was why it had no income was, well, really, it was just expenses she was paying for the partnership. And then we get into the whole bit about the partnership, the whole theory about, well, you can't do partnerships unless you have the partnership agreement requires you to pay those expenses. And of course, she wouldn't turn over the agreement because that was confidential. You can see how bad this is going for her in this case. She said a fraud penalty can be applied if the badges of fraud are there. Right? There are various badges of fraud. Found that she displayed multiple badges of fraud. This is the term we use here. Indications that you're trying to basically get away with underpaying your income taxes. She understated her income. She kept inadequate records. She gave implausible and inconsistent explanations. She failed to cooperate with tax authorities. She herself had a lack of credibility, and she created false documents. Court documents. Court said they found they were false. They said that basically counts as fraud. Failing to supply adequate records and falsifying documents is evidence of intent to conceal information from the IRS. Therefore, that would justify imposition of the civil fraud penalty in this case, right? Also found the IRS had received the required supervisory approval under 6751B1. You know what they must now have. And it met the burden of proof by presenting a civil penalty approval form signed by the revenue agent's supervisor, and this occurred before the notice of deficiency was issued to Chopra. Yeah, it's not going well for our taxpayers. She's having a really bad day, right? In the end, the taxpayers sustained the penalties and the assessments. Finally, we have the IRS has issued new guidance on Section 530 employment tax liability relief. This is Revenue Ruling 2025-3, Revenue Procedure 2025-10, both of which were issued on January the 8th. Now, this is updated guidance regarding Section 530 of the Revenue Act of 1978, which is an uncodified provision. It's not in the IRC. It addresses controversies involving whether individuals are employees for purposes of employment taxes and provides some protection to employers. If you work in the employment tax area, you should really be, aware of the 530 provision, right? Which was made permanent. It was meant to be temporary, but it became permanent. Revenue Procedure 2025-10, we're going to update for the first time since 1988, or 85, I should say. We're going to update and supersede Revenue Procedure 85-18. So basically 40-year-old documents, and change have been made since then. So we're going to update that. So this now becomes the primary revenue procedure you're looking at if you're trying to get Section 530 relief. Okay. Now, as I noted, 530 was not part of the IRC, right? It's meant for employment tax disputes. It can relieve a taxpayer from federal employment tax liability if certain requirements are met. This applies to the taxpayer and not the individual worker. The worker is still responsible for their share of the FICA and Medicare. Okay? That's basically going to be how this works. So, if you got paid and, you did that. Now, because it is FICA and Medicare, you're not responsible for the self-employment tax. So that's why it gets there. It doesn't bind the employee. It just allows the employer to get around this issue. So it works on that side. Now, basically, to get relief under 530, you have to not have treated the individual employee. That individual will not be an employee unless there was no reasonable basis for not treating them as an employee. The relief requires that all federal tax returns are filed consistently with that treatment of the individual as not an employee. Everything after, so 1979 and later returns. This goes way back. So you have to have always treated them as not an employee. And they've not treated any individuals holding a substantially similar position as an employee. So you can't just, let's say you can't be an accounting firm and get out of this. And accounting firms also have different rules, so maybe it's a bad example. But let's say, you can't just say that, half of my clerks in the store are employees. And then I started treating everybody who got hired later as independent contractor. Now, if there are similar people who are being treated as employees, you're not going to get 530 relief. If they're doing essentially very much the same position, you're not going to get this. And if you get this relief, you did not treat them as an employee for federal employment tax purposes, and you meet reporting consistency, substantive consistency, and reasonable basis requirements for having this. So essentially, right, we have that. You had to have a reasonable basis for your position. If treatment was based on judicial precedent, A past IRS exam that with changes to 530 meant it had to be an exam that actually looked at employment tax issues, a long-standing industry practice, or some other reasonable basis, right? It does not apply to technical service personnel such as engineers, designers, drafters, and programmers whose employment status is under the standard common law rules. So 530 protection does not work if you're, in essence, your engineering firm wanted to was treating all of its engineers other than the owners as independent contractors. You're not going to get 530 protection, right? It's going to be standard rule. And also does not change the status of individual as remain liable for personal employment taxes, right? An individual receives Section 5. If a taxpayer receives 530 relief, the worker is liable for the employee share of FICA. Now, as I said, it's actually advantageous because otherwise, if they're really treated as an independent contractor, they'd be subject to the self-employment tax, would be doubling that up with the employer section. So in essence, if this applies, the employee will still treat it as wages and file the, 4136 is it, where they're going to end up paying the FICA taxes on those wages. That would be the structure under the 530 structure, if you have 530 relief. It also examines whether 530 or the reduced rates of 3509 apply in 5 different scenarios. This is revenue ruling. So this revenue ruling gives us 5 scenarios. In addition to 530, it looks at 3509 that provides a lowered amount of, instead of what should have been withheld, you can pay lower numbers, to resolve a employment tax dispute, right? That's 3509. And also whether they'll issue a notice of employment tax determination under 7436 in those situations, which can allow the challenge to go forward. Okay. In situation 1, this was a case of a taxpayer hires individuals, pays them a weekly fixed amount and a weekly bonus. They do not withhold or pay federal employment taxes and reports a total payment on 1099 NEC. Right? So there are 2 types of payments, their standard weekly fixed payment and their weekly bonus. All of this going on a 1099 NEC, treating them as a contractor. In that case, that one becomes a textbook, and I'll get into this. That one is a textbook situation for 530 to at least be in the discussion, right? Right? So IRS determines in the exam that these people are employees, right? And don't qualify for 530 relief, right? The IRS proposed to assess for employment taxes on the payments, which should have been reported in Form 941 and Forms W-2. The taxpayer claimed it satisfied 530 relief. So they said in that situation, 530 is applicable. It could be applicable because the IRS is reclassifying these individuals as employees. That's important. 530 only applies if the IRS is reclassifying people you treated as not employees to employees, because all payments were paid on non-employee, or if it's paid as an independent contractor, 530 applies, right? Right. Okay. In this case, the IRS proposed to assess federal employment taxes on the payments, which should have been reported in Form 941 and Forms W-2, right? They claim they go for 530 relief, right? So essentially, whether it's entitled relief, depending on whether the taxpayer satisfies the substantive consistency, right? Reporting, did they always report it this way? Did they not treat anybody else who does the same thing, differently, right? And do they have a reasonable basis for treating them as not employees? If it does not apply, then Section 3509 with a reduced amount to be paid may be applicable because they treat them as non-employees, did not deduct withhold federal employment taxes. In this case, the IRS will issue a Section 7436 notice because the IRS determined individuals were employees. The taxpayer was not entitled to 530 relief, and there was disagreement between the IRS and taxpayers about the employment status of the workers. So that's a pretty traditional 530 situation. What they're going to show you in the next situation is what doesn't work. And unfortunately, we've seen clients who do things like this. In the second situation, we have employees and we have individuals, and we treat them as employees paying a weekly salary and a weekly bonus. They treat the salaries as wages for employment tax purposes, withhold, pays employment taxes, issues W-2s. However, they do not treat the bonus as wages and report that on a non-employee compensation without withholding or reporting any federal employment taxes. How many of you have seen clients who do that, something along that line? There is some category of amounts that they want to put on as non-employee comp. Okay. Now, again, this is going to be, let's say it's examined. The IRS says the bonus payments are wages. You couldn't show some other criteria while they were being paid under a separate relationship, separate thing. They're saying it's all part of the same thing, right? The taxpayer claims it satisfies the requirements for 530. That's on their claim, and so they're doing it. In this case, the revenue ruling says 530 is out the window. It does not apply. The IRS is not reclassifying these people as employees because the taxpayer already treated them as employees and paid additional wages in the form of bonuses. Also, the reduced rates under 3509 would not apply in this case. The IRS is going to go after the full amounts that should have been withheld and paid over by the employer, right? They're going to go for those, and you're going to be exposed to the income tax side of it if you can't show the employees that actually paid. We've got all kinds of weird little problems there, in that background, right? So it won't be, we're going to get the full, well, no, we wouldn't have a problem there with that because we did the 1099 reporting. That would help us there, but we're not going to get lower rates because the idea is you treat them as employees and you said this other stuff wasn't. It is. If the IRS wins, they're going to get the big payout. 3509 would not apply, and neither would this, and there's no relief under 530, right? So they won't issue 7436 notice because there was an audit. Termination was made, right? I said we'll issue that notice, issue 3536 notice, right? That'll be it. Now, situation 3, we have the same issue that we had in situation 2. So in situation 3, the taxpayer does not report the weekly bonus on Form 1099 NEC or any other information return. How does that change it, right? Section 530 and 3509 of the code are applicable. We'll issue 7436. Inclusion audit because there was an examination. Termination made the taxpayer was not entitled to relief. And the taxpayer, they disagree. So we have that there. The bigger danger here, though, not mentioned in this ruling, is you're on the potential hook for the fact of wages that they never reported the income, which is potentially a problem. This is the fact situation you're going to find sometimes when we look at things like when they reclassify, they were just giving away cash for Christmas and they claimed it was a gift from the owner to the employees. That doesn't tend to stand up. And that'd be kind of this situation and the third situation. Things like that is what we'd see. Okay, let's go to the fourth situation now. In the fourth situation, in this case, we have the same situation as the second one. Everything's the same as the second situation, except the taxpayer does not report the release bonus on NEC or any other information returns, does not claim to satisfy statutory requirement 530. In this case, 530 and 3509 are applicable, and they won't issue 7406. They did not claim they were entitled to relief under 530. There's no controversy where the employees are independent contractors. Finally, there is a third category here, which deals with the situation that we are going to have employed, in this case, the services of a third party to pay our individual's weekly salary, withholding, and pay employment taxes. Third party fulfills these obligations using its own employer identification number. Taxpayer pays a year-end bonus directly to individuals without treating it as wages, withholding, or reporting the bonus amounts on the information return. Ever seen that? They have a payroll service, but they go ahead and they make an extra payment at year-end. This can be that, quote, Christmas bonus, whatever it might be. IRS concludes those are wages proposed to assess employment taxes. It claims satisfies 530. Respect bonus does not agree the bonus amounts are wages. Section 530, not applicable. You can't get 530 relief in this situation because IRS is not reclassifying them as employees. Remember, IRS must be taking people who you treat as non-employees in whole and saying they're employees. They're not doing that. These people are employees. We're just now fighting over whether all the payment should be. The fact you use a third party that uses its own EIN doesn't change the situation for the taxpayer. The year-end bonus payments are additional wages for service performed by individuals who are treated as employees by a taxpayer. The reduced tax rates of 3509 will not apply in this situation for the same reason. You know, it'll issue a 7436 determination because it was an audit. The determination was made, the taxpayer is not entitled to relief under 530, and the taxpayer and IRS disagree on whether the statutory requirements for 530 have been met. So you're probably going to lose this one, but that's the catch. These illustrate how 530 applies. So if you have 530, these are all relevant in that particular background. As I said, it's been a very busy week, but this has been our developments for this week. So this was a long one. Current Full Tax Developments is always brought to you by your state society of CPAs and by Kaplan Financial Education. Remember, I do pay attention to, or take a look at the Connect sites for Arizona, New Jersey, Illinois, Minnesota, and Washington. You can try to reach me at edzollers@currentfulltaxdevelopments.com. Can't guarantee I can get back to things. We are hitting tax season now. Things are happening. And we get a lot of IRS stuff going on. So I've got the very end of my tax CPE sessions to do. And then I've got, all of the other tax stuff in the practice. So a little busy now, but, you can try there. Otherwise, we plan to hopefully see you back here next week, talk to you about new developments for that week in question. And hopefully you're having a wonderful year so far. And you're getting ready for the whole start of tax season, which, by the way, I didn't mention it, but the IRS announced this week, January 27th is when they're going to start accepting returns. So you can pencil that in your calendar. So about then tax season goes, we're underway, the fun all starts. In any event, we'll see you back here next week for more current federal tax developments.